further ado, I'll turn it to Beth. Thank you, Beth.
Thank you, Gunan, and welcome. I assume you can all hear me. If not, please let me know. But welcome. This year, this coming year of going again, it's going to be such an important year for our democracy and for political discussion. So we will probably be having both live and Zoom First Tuesday talks, and we'll be sending out, and we invite you to come. We always have interesting programs. We'll be talking about the important issues that come up in 2024 as we approach a presidential election. And it's also a great time just to catch up with your friends in the league, to bring your friends, to expose them to the league and the important work we do. But we are so fortunate today. We have Dr. Courtney Thomas here to talk with us about the impact of a recent U.S. Supreme Court ruling on LBGTQ rights. And Dr. Thomas, who has deep roots here in Virginia with her family, both here in the Blacksburg area, but also in the Lexington Natural Bridge area. Dr. Thomas has also been following and analyzing some of the guidelines issued by the Youngkin Administration in July on transgender students. So, and she is well positioned to talk to us today. Her research and teaching emphasize mass political violence, the political economy, international relations, queer politics, and public policy. So you can see we are fortunate to have somebody who has her finger on the pulse, and we're eager to hear, Courtney, from you today.
Thank you so much for having me. I'm thrilled to be with you. I would like to, before I get started, I want to add a couple things to that. The first is that I'm a professor of political science. I'm also the parent of 3 students in Virginia public schools, including one child who is a non-binary transgender student. And so the experiences that I've had with my own education and professional choices, and then with my child, have certainly informed the way that I approach this issue. And I'm also going to start with notes because all of my students will tell you that if I don't have notes, I'm never going to make it through anything. They'll also tell you that I am very ambitious when it comes to how much I plan to get through. My students call it ambitious, my staff calls it unrealistic, and my husband says I just talk too damn fast. But I am thrilled to be with you guys today to talk about some of these issues that are centered on the really important political and policy questions that address public education and our children and our schools. But I'm going to start with a question because I'm a teacher and I don't think that I should be doing all the talking. So I'd like to start with a question, and I think we have people who are looking at the chat. When did you, I want you all to take a second and think, when did you first become aware that transgender student rights were a political issue that you were supposed to know and care about? When did that happen for you? And I'll start by saying that it happened for me when my child came out as non-binary several years ago. That was the first time I had ever thought about it. And I only thought about it because it was personal. 2012? Because that's a while. That's incredible. 2008 on the board of Equality Virginia. I love this. Anyone else? Those are much earlier answers than I was anticipating.
I can't get my chat, but I would say for me, it was probably 25 years ago because my sister-in-law was involved in issues in New Mexico. And even some of those interested in gay and other rights felt like, oh, transgender is just too controversial. Let's just, we'll fight for gay rights, but let's leave the transgender.
Let's not touch that. Yeah. When elected to the school board, absolutely. So I think for a lot of us, it feels like this has been a real flood of awareness and information that has come in the past couple of years. And the question that I get most often when I talk to people is, why now? Why are we having these discussions right now? 2015 to 2020, what is it? What has gotten us to this point? And why is it that so many of our political discussions at the local, at the state, at the national level are focusing on this issue right now? And so what I'd like to do today is I'd like to take you through a story. And we're going to start that story with the catalyst for a lot of what we have seen happen locally and in Virginia. And then I'd like to talk a little bit about the transgender model policies under both the previous administration and the current administration. And then I'm going to tie that back together with this Supreme Court decision so that we can talk about what the future of these issues is likely to look like. All right, so in 2015, the Supreme Court legalized gay marriage in the United States. And that was seen as this huge accomplishment. It was this major watershed moment for LGBTQIA+ rights. But if you were opposed to gay marriage, or if you were trying to organize voters for conservative candidates or parties in the United States, the Supreme Court's decision to legalize gay marriage created a problem. One of those groups is the American Principles Project. Has anyone ever heard of the American Principles Project before? It's one of the groups. It's one of those groups that it operates. It raises a lot of money. It spends a lot of money. It does a lot of things, and yet we don't really know what it is. Most of us aren't familiar with this group or what they're trying to do. The leader of the American Principles Project said that after the 2015 Supreme Court decision legalizing gay marriage, we knew we needed to find an issue that candidates were comfortable talking about, and we threw everything at the wall. What he is saying here is we knew that we needed to find a way to turn out voters. We knew that we needed to find a way to raise money. We knew that we needed an issue that would mobilize voters, that would mobilize candidates, and that would mobilize money the same way that we were able to use gay marriage as a mechanism of mobilization previously. And so this organization sits down and they throw everything at the wall, all these issues. What will stick? What can we use going forward in order to mobilize voters, in order to raise money? And they were as surprised as anyone when it turned out that the thing that people could be mobilized to care about were transgender student rights. And so they started digging deeper into that. What were the mechanisms that they could use in order to win elections, in order to turn out voters, in order to raise money? In 2019, in a gubernatorial election that was not about transgender rights, had not addressed transgender rights, had not really considered the issue of transgender rights, the American Principles Project, through money and through public communications, advertisements, commercials into the fray, all focused on the issue of transgender athletes in women's sports. In doing so, the Republican candidate that this organization was supporting with this information project won the election by 5,000 votes. They were able to flip a gubernatorial election by politicizing transgender student rights. This is the proof of concept. This is the realization that this organization is going to be able to politicize the issue of transgender student rights in order to win elections, in order to turn out voters. And as soon as that happened, other groups began to take notice. And this was especially true after the Dobbs decision. So gay marriage and abortion, both the legalization of gay marriage and the overturning of Roe v. Wade created an opportunity for people to essentially sit out politics. If the gay marriage decision is decided and Roe versus Wade is overturned, how do you turn out voters who for years have been willing to come out and vote based on those issues? How do you keep those people showing up at your polls? with the proof of concept from Kentucky, with the 2019 Kentucky gubernatorial election, other organizations like the Alliance Defending Freedom, the Christian Action Network, and the Family Foundation of Virginia, all of which we'll talk about as we go forward, realized that they too could politicize transgender rights in order to try to continue to turn out voters, in order to continue to impact elections at the state, local, and at the national level. So within this context, in 2020, Virginia passes a law. Let me see if I can get it to go to my next slide. Work with me here. There we go. In 2020, Virginia passes a law. This law is really quite simple. So the 2020 law requires that the Virginia Department of Education develop and make available to local school boards no later than December 31st, 2020, model policies concerning the treatment of transgender students. And then it requires that school boards across Virginia adopt policies that are either consistent with or more comprehensive than those model policies by the beginning of the 2021-2022 school year. And those policies have to cover 8 different areas: compliance with applicable non-discrimination laws, maintaining a safe and supportive learning environment, preventing and responding to bullying and harassment, maintaining student records, identifying students, protecting student privacy, enforcing sex-based dress codes, and student participation in sex-specific school activities and events, excluding athletics. And I want to be very clear that the 2020 law explicitly excluded athletic participation. It left athletic participation to the VHSL, the Virginia High School League, which oversees high school athletics in the state of Virginia and has its own policy for the participation of transgender students. That policy has been in place for a while. That policy has been controversial. There's been some criticism of it, but the state legislature decided to leave athletic participation to the VHSL rather than to cover it under these model policies. So why was this law necessary? It's really important to understand that this law did not give transgender students rights. This law is not giving any student in the state of Virginia a right that they did not already have. Transgender students have rights already. They have those rights under federal laws, including Title VII and Title IX. They have those laws under the 14th Amendment to the U.S. Constitution. They have rights under applicable state laws. They have rights under relevant case law, like the Gavin Grimm decision, which allowed transgender students to use bathrooms that align with their gender identity and not their sex assigned at birth. Those rights that transgender students have, those are already established in relevant federal and state laws. This 2020 law by the Virginia government, it does not give transgender students rights. What it does is inform local school boards of the things that they need to do to protect those rights. Across the state of Virginia, we had very uneven application of relevant civil rights laws as it applied to our transgender students. Many school systems did not know what they needed or what they could do to protect transgender students. My child came out before the 2020 law passed. We were flat out told by our school system that they just didn't know what they could do to guarantee that our child have a safe and equitable education. What this law is doing is giving school systems information that they need in order to protect rights. And it covered these very explicit areas of policy, and it had a very specific timeline for implementation. Now, the VDOE, sorry, I'm gonna throw away the cat. The VDOE does not actually meet its December 31st, 2020 deadline. The COVID pandemic kind of delayed things. That model guidance doesn't actually come out until 2021. But it does come out in 2021. And the law very explicitly required that the model guidance from the VDOE be developed in accordance with evidence-based practices. That this guidance from the VDOE to local school systems had to be based on the best available science about the treatment of transgender students. So in 2021, a little later than the deadline, but in 2021, the Virginia Department of Education released the model policies for the treatment of transgender students in Virginia public schools. You can still access this guidance. It is still available. It begins with a discussion of all of the people and organizations and groups that worked on this guidance. And that included policy analysts, social workers, students, psychologists, school nurses, Title IX coordinators, PTA and PTO organizers, school board members, superintendents, transgender support groups, the Virginia School Board Association, parents. This was a huge undertaking. And if you look at this document, the first several pages of the document lists all of the different people who participated in the elaboration of these policies. This document also included a summary of the appropriate terminology used in this discussion, things like what it means to be transgender, what it means to be non-binary, what gender identity and expression are, so that we were all starting with the same vocabulary. It included a summary of all of the relevant laws, the First Amendment, the 14th Amendment, Title VII, Title IX, the Equal Access Act, FERPA, HIPAA, all of the things that gave students these rights to begin with. And then it provided model policies for local school boards, as well as a rationale and a justification for each. So this document, so I'm trying to look to make sure I've got the right page. This document's like 30 pages long, and it includes very detailed explanations for why these specific policy proposals are both necessary, why they're based in relevant research, evidence-based practices, why the VDOE is recommending this specific language be adopted by local school boards rather than some other understanding or some other policy that they might come up with. This is released in March of 2021, and school systems have until the beginning of the 21-22 school year to adopt them. So the policy is released, the model guidance is released. What happens? Well, there are some groups that advocate for the passage of the VDOE model policies. They say these policies are what fulfill the terms of the 2020 law. They should be adopted by school boards. This is what school boards should do. Some people protested against them. Across the state, there were protests against the implementation of these policies. You saw people showing up at school board meetings to speak against the implementation of these policies. And yes, you saw the beginning of what would ultimately be lawsuits to prevent the implementation of these policies altogether. One of those lawsuits was brought by those groups that I mentioned earlier, the Christian Action Network and the Family Foundation of Virginia. These two organizations tried to stop the implementation, the adoption of these policies before they were even implemented across the state, saying that they represented an overreach by the state government, and they violated the rights of families who did not agree with these policies as they were outlined in the model guidance. That lawsuit was brought in Lynchburg, and it was dismissed because the judge in the case said that the plaintiffs, those bringing the suit, did not have standing, that they had not been harmed by the implementation of these policies, and therefore they did not have the right to stop their implementation. That's really important. Hold on to that. I'm coming back to that pretty soon. Across the state, we saw a real hodgepodge of implementation efforts. Some school systems adopted policies based on the VDOE model guidance, sometimes with revisions. I've seen some different numbers. I've seen 14. I think the most consistent number I've seen is 13. As to how many revised, I think people count differently based on how much revision there was. I've seen anywhere from like 8 to 9 adopted with revision. About 90 decided not to adopt policies that were consistent with the VDOE model guidance, and instead followed the direction of the Virginia School Board Association and updated their non-discrimination policies to include gender identity and expression, but did not pass policies specific to those 8 areas of policy as the law required. And then about 30 school systems did nothing. They either outright rejected the VDOE's model guidance, or they just never voted on it at all. They did nothing. They did not act on the basis of that 2020 law. And if you're wondering how is that possible, well, the answer is there was no enforcement mechanism. This law did not include any enforcement mechanism. There was no way to compel local school boards to adopt these policies and conform to this 2020 law except through lawsuits. So if you were the parent of a transgender child, or if you were a transgender student who was an adult, who was 18 or older, and you were in a school system that had not adopted these policies, you could theoretically bring suit. You would have standing, you would be harmed by your school system's failure to enact these policies, and you would be able to bring a lawsuit to compel your school system to adopt these policies. But in the absence of those cases, there was no enforcement mechanism. There was no way to force school systems to adopt policies consistent with this law. Now, I will say, these numbers don't look great. 13 to 90 to 30 don't look great. I will point out, though, that the largest school systems in the state were included in that 13, and there are LGBTQ plus organizations that estimate that about 50% of Virginia students do attend school in counties that are part of that 13. So about 50% of Virginia students were covered by those 13 counties that did adopt policies based on the model guidance. All right, so that's 2021. In 2021, Virginia has a gubernatorial election. And this became a critical issue in Virginia's gubernatorial election. Governor Youngkin makes transgender rights an issue that is central to his campaign for governor in 2021. And he creates what I'm going to tell you is a false dichotomy. He creates a false dichotomy between transgender rights and parent rights. These are not mutually exclusive. You do not have transgender rights or parent rights. You can have both. I am a parent. I have a transgender child. My parent rights involve supporting the rights of my child. This is a false dichotomy. And yet he was very effectively able to do what the American Principles policy said that he was going to be able to do by focusing on three key issues: student identification, transgender girls competing in on school athletic teams, and access to bathrooms and locker rooms. He was able to make this an issue that turned out voters. So in 2021, in Virginia, we see all of the energy that was going into those protests in July and August, then coalesce in the 2021 gubernatorial election. In 2022, in response to this, the VDOE publishes the first draft of what Governor Youngkin's new model policies will look like. And everybody across the state has really strong feelings at this point. About 70,000 people across the state submit public comments on these new model policies. It is a huge flood of people, some in favor of the new model policies, some opposed to it, but this massive flood of public comment goes to the VDOE. And by law, the VDOE does have to review and respond to those comments. Meanwhile, the Democratic majority in the state Senate blocked a dozen anti-transgender bills in the 2022 session focused on bans on transgender athlete participation, gender-affirming healthcare bans, and the forced outing of students to parents. So what we are seeing is that in 2021 and 2022, Virginia is falling into the nationwide model of legislation, over 150 bills each year, designed to curtail the rights of transgender students. In 2023, right before the 2023 Virginia midterm elections, the governor's office released the model policies on ensuring privacy, dignity, and respect for all students and parents in Virginia's public schools. This is the policy, this is the VDOE guidance that the governor says replaces the 2021 transgender guidance. It is to fulfill the obligations under the 2020 law. I will point out that even in the title, it doesn't mention transgender students. This policy departs from the previous policy in a couple of really important ways. First, it completely omits non-binary students. Non-binary students who are mentioned as transgender and included as transgender in the 2021 guidance are completely erased by the 2023 guidance. This is directly connected to the Christian Action Network's requests in their lawsuit in 2021, when they said that non-binary didn't exist. It was liberal propaganda, that it had no place in state guidance or local policy, and that it needed to be excluded from all state documents. In addition, the 2023 model policies depart from the 2021 guidance when it comes to student identification. In the case of student identification, the 2023 model policies say that a student's name and pronouns will be determined by their sex, except as requested in writing from parents. So teachers, staff, administrators are not permitted under this guidance to identify students based on the names and pronouns they choose unless they receive written instructions to do so by the parents. Even if they receive that instruction, even if a parent, such as myself, says, "This is my child Betty, Betty uses Zer pronouns," any teacher, any staff member can refuse to use that name and pronoun. So this is based on another piece of the 2023 model policies that says that school divisions shall not compel personnel or other students to address or refer to students in any manner that would violate their constitutionally protected rights. What this means is that teachers, staff members, school employees could refuse to use a transgender student's name or pronouns if they argued that using that name or pronoun would infringe upon their rights to free speech, their rights to religious expression, their rights, their constitutionally protected rights. In addition, the 2023 model policies say that access to locker rooms and bathrooms shall be based on biological sex, except to the extent that federal law requires otherwise. Now, the Grimm decision, the Gavin Grimm decision, is still the law in the state of Virginia. That was a Virginia court decision, and that decision said that transgender students get to use the bathroom and locker room that aligns with their sex, with their gender, not their sex identified at birth. What this is doing is establishing a trigger policy so that if the Supreme Court overturns the Grimm decision, counties in Virginia could automatically deny transgender students access to bathrooms and locker rooms that align with their gender identity instead of their sex assigned at birth. And then finally, even though the 2020 law said that athletics were excluded, completely excluded by law from these policies, the 2023 model policies said that students could only participate on athletic teams based on their sex identified at birth and not on their gender identity and expression. So we have this very, very different document, this incredibly different document published by the Youngkin Administration, and the governor and the Attorney General of Virginia both say outright that school systems are required to adopt these policies, to replace their existing policies with these new ones. Now, to go back to the 2020 law for just one moment, the 2020 law said that the VDOE would publish model guidance by the end of 21, and that school systems would adopt that guidance. They would adopt policies consistent with or exceeding that guidance by the beginning of the 2021 school year. The 2020 law did not provide a mechanism for the VDOE after that to go back and rewrite the policies and then compel school boards to pass new policies. That did not happen. That was not part of the law. But the governor and the attorney general say that that's what school systems in Virginia are required to do. So what happened this past fall? Well, there were protests and arrests. There were threats of lawsuits. There were advocacy campaigns. And what we have at this point is that some school boards have adopted policies based on the new model guidance. As of right now, that's 3 across the state. There might be more. 3. I've come up with 3 in my last look through of the list. That's Spotsylvania County, Roanoke County, and Virginia Beach. Virginia Beach only adopted the new policies after they were sued. They were sued by parents who wanted the new policies adopted. They caved, they reversed their vote, adopted the new policies, and the parents dropped the lawsuits. So clearly lawsuits are going to be a mechanism for this issue across the state. And then you have most of the school systems in the state of Virginia who have done nothing. Either they've done nothing either time, or they have left their 2021 policies in place. Several school systems made a lot of noise about how they were going to leave those policies in place, and have said outright that they do not intend to change them. But there is still no enforcement mechanism except lawsuits. And this is where we get to the point of what I was supposed to talk about. But that said, I'm going to be honest with you guys. The 303 creative decision isn't actually that interesting. It's fascinating, but not really relevant to a lot of things that are happening statewide. See, here's the thing. There are a lot of court cases about LGBTQIA+ rights. There are a ton of different ones across the country in different district courts, in different appeals courts, and they all say different things. Some of them say that trans rights are protected under Title VII. Some of them say they're not. Some places say that transgender students have the right to participate on athletic teams that align with their gender identity and not their sex. And some places say they don't. Some places say that students are allowed to use the pronouns that they choose, and some places say that they don't. There's just not a lot of consistency. And when there's not consistency, that's when you expect the Supreme Court to act. So let's take a look very quickly at what they did in 303 Creative. In the 303 Creative decision, the Supreme Court said that people could not be compelled to speak against their strongly held religious convictions. The decision in that case was that the government could not use non-discrimination or public access laws to compel speech from a person. So in this case, a business owner who said that she might want to make wedding websites one day, and she might be asked by a gay couple to make a wedding website. And if she was asked to make a wedding website for a gay couple, she would say no, because it's her strongly held religious conviction that gay marriage is not biblical. And if she said no, the state of Colorado might punish her for that speech. That's a lot of mites. Just saying, that's a lot of mites. And so she needed to be protected against that possible 3 steps removed violation of her rights. The court should have thrown this out, flat out. They never should have heard this. They never should have heard the case, because she did not have standing for this lawsuit. She had not been harmed by any policy, but they did hear it. And what the court ruled was that she could not be forced to make a website for a gay couple if that violated her strongly held religious conviction. The reason this case matters as it pertains to queer rights is really in 2 different places. First, it guts non-discrimination law. If you can say, I have a strongly held religious conviction that I should be allowed to discriminate against this group of people, and the court says that any state effort to prevent that is a violation of my religious liberties, it becomes very difficult to enforce non-discrimination law against queer folks. And we have seen courts across the country hesitant to apply civil rights law to queer populations because of this. But the second thing that this did was it absolutely eviscerated the entire idea of legal standing. What this means is that you no longer have to be harmed to bring a case before the court. And that means that that across the country, you have teachers who are saying that policies that compel them to use a transgender student's name or pronouns, or to allow transgender students to participate on athletic teams, or to allow transgender students to use the bathrooms that align with their gender identities, that is a violation of their strongly held religious beliefs. This is going to be decided by the court at some point. And the most frustrating part of this, and where I'm going to leave you, is not good. We have absolutely no way of knowing how the court's going to decide on these issues. We can't predict it. We don't know. We know that this court seems inclined to listen to organizations like the Alliance Defending Freedom, the Christian Action Network, and the Family Foundation of Virginia, that those arguments seem to be compelling. But this court is also willing to throw out its own rules, its own precedents. There's no way to know how this is going to end. But what we do know is that the 303 decision has had a chilling effect on queer rights across the country, because lower courts are now afraid to extend civil rights protections to queer individuals, because they're afraid that the court will strike that down based on this precedent. And so if we're concerned, as I think many of us are, about the rights of transgender students, about the rights of queer individuals within our communities and within our society, this is a really scary time, because the only mechanism of redress is a lawsuit. And the legal structure seems to suggest that the court is not going to be friendly to those cases. Any questions?
Yes, Peggy and Jess and Molly, can people speak up, or should it all be on chat?
Any way is perfectly fine with me.
Okay. Can people unmute themselves if they want to ask a question? Because I'm sure there are some questions or comments. Let's see.
Yes, they may.
So you can please, those of you,
Carolyn.
feel free to unmute yourself and ask questions.
Carolyn, absolutely. Standing could equally apply to trans students and their parents. So for example, I could bring suit in a county that I might want to move to one day based on how they might treat my transgender child. That theoretically, under this ruling, that would be possible. Now, whether the court would accept that or whether they would throw that out for lack of standing, I don't know, because the rules no longer matter. That's one of the major concerns here, is that the rule of standing no longer seems to matter, or at least it selectively matters. And so, yes, I mean, theoretically, this could be an opportunity for a parent of a transgender child to challenge a policy in a school system their child is not enrolled in theory. Possibly. Yeah, Molly.
Yeah, Courtney, most of us on the call are in Montgomery County. So would you just talk a little bit about the history of transgender rights in Montgomery County public schools and where things stand today with regard to these guidelines?
Yes. So I will start in 2021. So in 2021, the Montgomery County School Board did adopt policies that were almost completely based on the VDOE's 2021 model policies. There were a couple of changes. As it turns out, those changes might have actually worked in its favor. So one of the changes that Montgomery County made was that a parent and student had to request a change of name and pronouns. The VDOE 2021 model policies said that a student or parent could make that request. So it allowed students to make that request if they chose, or it allowed a parent to make the request on behalf of a student. In Montgomery County, the school board voted to require a parent and student to make that request together. So in 2021, that policy passed. As of this point, the Montgomery County School Board has not indicated that it is going to change that policy. So it has not been on the agenda in the past few months. It's not on the upcoming agenda for tonight. And so it looks like that Montgomery County has decided that its current policies satisfy its legal obligations under the 2020 law and other relevant state and federal laws. This is one of several instances where the current governor has turned law on its head. What recourse is there for believers in the separation of power to restore respect for the law? Well, normally I would say the courts, but unfortunately, it's very hard to know if that will work. So, you know, I don't like to be I don't like to be alarmist. But I do want to point out that since 2016, the Democracy Index has classified the United States as a flawed democracy. We have institutions, we have rule of law, we have checks and balances, but the extent to which they're working is kind of a big question mark right now. And so certainly the General Assembly is essential in providing a stopgap. We saw this in the 2022 session. In 2022, the democratically controlled Senate was the only thing that stopped 12 anti-transgender bills from going through and becoming law. But a lot of this is also left to the judiciary, and so it becomes really complicated in terms of how a lot of these things are going to turn out. The first consequence of the South Carolina of Supreme Court action was so it gutted the application of non-discrimination and public accommodation laws to queer individuals if the objection was a deeply held religious conviction. So in that case, the plaintiff argued that she had a deeply held religious conviction that marriage is between one man and one woman, and therefore it would be a violation of her religious liberty to make a wedding website for a queer couple. And what the court ruled was that a non-discrimination or a public accommodation law that would compel her to make that website would violate her First Amendment rights. And because of this, across the country, we see courts that are really hesitant to apply non-discrimination and public accommodation laws to queer individuals, because based on this precedent, they would be struck down.
Courtney, this is Beth Obenjane.
Hey, Beth.
I have a very conservative niece, and when this issue comes up, the first thing she talks about are athletes.
Sure.
Do you think it's fair? So could you talk about, you know, how often this has come up in Virginia? And
almost never.
It does seem to be a real hot button issue in political discussion.
It absolutely is. And the reason it is that the American Principles Project realized that the number one thing that they could do to turn out voters, to make people angry, and to raise money was to focus on athletics. Transgender athletic participation was the number one issue that checked all their boxes. So here is the deal. Very few transgender athletes participate in VHSL sports, let alone at the NCAA or the Olympic level. It's very, very rare. The Virginia High School League's policy has been in place for over a decade. 34 transgender athletes have been approved to participate in Virginia since the VHSL passed its policy. Here's the thing, that policy is a high bar to clear. So in order to participate on an athletic team that aligns with a student's gender identity rather than their sex assigned at birth, those students have to produce documentation that shows that their gender identity is persistent, consistent, and explicit. That is to say that you can't just be a male student, show up the day of a race, and then decide to run against the women. You can't do that. That's the perception that has been propagated but it's just not based in any reality. The student has to demonstrate that they live as that gender, that is their persistent and consistent gender identity. They have to demonstrate, they have to have letters from family members and their principal that this is the gender identity and expression that they adopt more generally. And then they have to be approved for that participation by the VHSL. Now, the athletic rules do not, okay, so the athletic rules don't allow for non-binary students. Yes and no. So there's certainly no, like, there's no mechanism for non-binary students, right? So non-binary students, the VHSL policy definitely does have a gap where it applies to non-binary students. So non-binary students are able to participate, but they default to participating in the on the team that aligns their sex identified at birth in most cases. It's a solution in search of a problem. There is no problem of trans women dominating women's sports. It just doesn't exist. In order to participate in the VHSL, in the women's category, an athlete has to prove that they have gone through medical transition such that they no longer have any biological advantage that would serve them in that sport. It's not an issue. And you know, from on the other perspective, the other thing that I would say is the vast majority of our VHSL athletes, they're not going to go on to compete at the NCAA level. They are not going to go on to compete as elite athletes. School sports are an essential piece of building community, of acceptance, of building positive body image and discipline. And transgender students often struggle with mental health.
Yeah, it seemed to me that when you look at the minuscule number who are trying versus the number of students, transgender students who have mental health issues, that
and the other thing I would say is that this whole discussion also hurts cisgender students. There is a perception that there's this huge number of so-called biological boys who are competing on VHSL teams, such that young people will often accuse cisgender athletes who don't look feminine enough of being biological boys who are cheating. That's not okay either. We have just created discriminatory language that is seeping into our children. It's gender policing, and that's not okay either. That not only hurts transgender children, that hurts cisgender children who don't look feminine enough and are accused of somehow being something that they're not, or violating policies that they're not violating. So this is a problem across the board, but it's not a problem for the reason that people think that it is.
When those cases
it does happen.
Yeah, when those cases come up, they get a way disproportionate amount of publicity, which gives people the impression that it's a frequent occurrence. But
it's really, really common, and it just isn't. The numbers don't support that. Yeah. And we're being manipulated. We're being manipulated by groups with huge amounts of money who want you to be concerned and who want you to be angry, because they think that they can turn that into votes in their favor. And there's a huge amount of money that is going into making this seem like an issue when it's not.
Any other questions? This has been just a fascinating presentation. I think even some of us who might have thought we were well informed on this issue realized what little depth we had. So, Courtney, this has just been a fascinating presentation.
I'm so glad to be with you. I could do this for weeks. Carolyn,
Carolyn has her hand right.
Yeah.
Yeah, this one I think it's maybe too difficult to express in typing. What I'm not clear on is this exemption for deeply held beliefs. If you're a teacher, does this only apply to trans students? Does it only apply to LGBTQ students? or does it apply to other protected classes?
I don't know. So let me answer that question the best way I can. The 303 creative decision, so that specific decision had to do with with creating a wedding website for a gay couple, and the deeply held religious conviction that marriage is between one man and one woman. That would seem to suggest that the precedent applies to LGBTQIA plus individuals, of which transgender students would be part. But whether that can be extended to other areas of civil rights law and protection, I don't know. Possibly. So in theory, the Supreme Court is supposed to rule on the narrowest possible issue of law. But they're not following their own rules when it comes to standing or precedent or anything else. So what would make us think that they're going to abide by those norms either? This could apply. This could be applied narrowly only to transgender students, or only to queer students or queer individuals, or this could be applied broadly and undermine a lot of our civil rights, non-discrimination, and public accommodation protections. Yeah, exactly. For the Lovings, when it comes to racial discrimination, this really opens a door, and we don't know how wide it opens it. The other thing that I would say, and those of you who are teachers or school board members or connected to public education know this, teachers occupy a really bizarre place because they are at once employees of a government entity. They're public employees, but they are also the agents of the state. So what happens when you have a teacher who says, I have a strongly held religious belief that sex and gender are assigned at birth, that there are two genders, male and female, and God makes that determination at birth. That is my strongly held religious conviction. And I have the right to enforce that on this student. But the student says, well, I have a strongly held religious conviction that my gender is determined by me, that transgender people are part of God's creation. Like, what happens when the teacher's strongly held religious conviction and the student's strongly held religious conviction cross paths? Which one wins out? We don't know. And that's a horrible position. That's a horrible position for school systems to be in, because I don't even know what their legal liability is as far as that goes.
Courtney, if you scroll up a little bit, Kai had a comment and a question about bullying and how it relates to this. And Kai is a retired teacher.
Kai, I'm gonna say, and this is the thing that gives me probably the most joy in my work and my life. Your question is, we've spent so much money and so much time teaching kids about bullying and not being bystanders. How are our young people making sense of this? They're not. Young people are so much more accepting. They are so much more welcoming of people who are different. Our students are really open to the idea that you've got all kinds of different people and that those people deserve to have dignity and rights. In the 6 years, I've gotten old. In the 6 years that we have been, working with this as a family because of our child, I have heard so many adults tell me that my child doesn't deserve rights, or that my child is dangerous, or that my child should not be allowed to express themselves. I've never once heard a child say that. The children are really open in most cases that I've seen to the lessons that they have been given about how people are different and how they deserve respect and dignity. And yes, I think our students have been so inspiring. Watching students show up to talk at school board meetings, watching students organize themselves. If you've been watching the Montgomery County school board meetings, we have had a parade of students who have come through, and they have spoken with so much poise and so much conviction. We're gonna be all right. They're gonna the kids are okay. And that's an amazing thing to see.
Well, that's a great positive note, and that I hope we can all end on. Thank you so much, Courtney. This has just been a fascinating topic, and the depth of your knowledge of it has been terrific for us to hear today. So
thank you so much. I am happy. If anybody has additional questions, I'm happy to answer them. I've dropped my contact information in the chat.
great.
And I would be happy to answer questions as they come up. I'm so thankful that you invited me to be with you today.
Thank you again. And thanks to all of you who are here and now have a better understanding of this issue, and hopefully can share it in your communities and in our community. So thank you so much. I hope everyone has a wonderful holiday, and we will see you again. We will not have a first Tuesday on January 2nd. We assume everyone will still be recovering, but we will look forward to seeing all of you in 2024. Thank you so much.
Thank you so much.
And thanks to